parties were continuing to engage in marriage counseling, continuing to have dates, continue to have a romantic relationship. Defendant left the home on plaintiff's insistence that this was the only way to save the marriage.
My client, unfortunately, has nowhere else to live.
This nonsense about a past event that happened between defendant and his sister is absolutely irrelevant.
Court will note the appearance of Mr. Todd on behalf of plaintiff, Ms. Capture on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, exclusive use of the home. Mr. Todd.
Thank you, Your Honor. Your Honor, in this particular case, the plaintiff is the person who has taken the majority of child rearing. This is allegedly disputed given my client's work history. However, she has not worked more than 60 hours since Gemma was born. She is the one who has done all the cooking, all the cleaning, all the bathing, made all the appointments, helped the children with schoolwork in terms of reading and everything like that. Additionally, the parties separated April 6th of 2024, and the opposing party did not return until approximately 2 weeks before this motion was filed. So he was out of the home for more than 4 months, with the exception of a couple weeks. We believe that it's in the best interest of the children for plaintiff to be granted primary custody. Additionally, after the defendant left the home in April, it is accurate that he spent a couple nights at the home. He sometimes would come and see the children, and there were approximately, I believe, 3 times where he stayed overnight. He slept on the couch, and this was because my client didn't want him to drive back to Reading if he was tired. This happened, again, I believe only about 3 times, and he has had no unsupervised overnights. It is not accurate that defendant was the primary caregiver at all. This doesn't really even make sense on its face because he was gone for over 4 months. So that simply can't be true. Additionally, my client provided all of the drop-offs for the minor children and all of the pickups, with the exception of an occasional pickup by the opposing party on Mondays. It is accurate that there was a period of time that the parental grandmother was helping with the children, but that actually stopped in June of 2024, I believe. And so this didn't necessarily continue beyond that. There is the allegation that my client, again, works in essence too much to provide for the children. That's simply inaccurate. Again, for the past 4.5 months, she has been doing this herself. She does occasionally work after she puts the children to bed, but again, she's fully capable of doing this and has done this. The defendant lived in Reading for the entire time from April since a few weeks ago. He states that after reconciliation he thought this was for reconciliation, and then he immediately came back. That's not accurate. He waited 4 weeks after the divorce was filed to come back home. In terms of the defendant did previously admit to molesting his sister 2 or 3 years. This event occurred for 2 or 3 years. There's an allegation that our time frame for that is inaccurate. But if this was disclosed in 2012 and stating that this was more than 20 years ago, that time frame is simply not accurate, because that would have made the opposing party 2 or 3 years old. So we believe our time frame is significantly more accurate. There's an issue with the opposing party's anger. He becomes extremely violent, controlling. He has these outbursts. This is denied, but there is a specific example of when the parties were at the Tulip Festival. He became enraged and threw some cookies in a trash can, damaged the trash can, and then ran down the hallway and slapped the child on the leg. This is just an example of behavior that has continued. He has had angry outbursts, destroyed marital property, smashed and thrown things. We do believe that, again, my client has had the vast majority of parenting time, and that's evinced by the fact that he has been, in essence, out of the home for the vast majority of the past 5 months. The children have a consistent routine in the current household. They have always lived in this household. Additionally, we believe it's in the best interest of the children for plaintiff to be granted exclusive use and possession of the home. Again, the other party moved out and lived in Reading previously. We don't understand why that, in essence, can't continue. We are respectfully requesting additionally that the parties continue to deposit their checks into the joint account, as that has been the status quo. My client, unfortunately, has nowhere else to live. The police have already been called once within this 2-week period since the opposing party moved back. So we do not believe it's an appropriate place for the children to be when both parties are there. So we are respectfully requesting my client be given primary physical custody, defendant have supervised parenting time, a Wednesday week visit, and 1 overnight every other week. This is more than he was getting for the past 4 months. Also, we're requesting anger management counseling and a psychological evaluation. I do have a company that can do that. That company is Child and Family Psychological Services. And then upon completion of that the supervision requirement be lifted. Additionally, we are requesting no drugs or alcohol 12 hours before or during parenting time. The plaintiff be granted exclusive use and possession of the marital home. And we are additionally requesting that the parties continue to deposit their joint accounts in, or their checks in the joint account deposit.
Okay, thank you. Ms. Capture?
Thank you, Your Honor. I think the biggest discrepancy here is that defendant left the home and the parties separated. That's not the case. The parties were continuing to engage in marriage counseling, continuing to have dates, continuing to have a romantic relationship. Defendant left the home on plaintiff's insistence that this was the only way to save the marriage. Defendant continued to work in Calhoun County, had parenting time nearly every single day. The only reason he wasn't getting overnights is because plaintiff's insistence that this was the only way to save the marriage. Reading is over an hour away. It is not realistic for him to continue to maintain a traveling distance if the parties are going to get divorced. He was trying to save the marriage. That no longer is working. Both parties own the home. Defendant continues to pay all of the expenses on the home. Plaintiff is unable to pay all of the expenses on the home. If she believes that she can't stay in the home with defendant, then she is welcome to go get an apartment by herself and pay for that. Otherwise, if it is the court's desire to have plaintiff get exclusive use of the home, then she should be responsible for all utilities, taxes, mortgage, insurance on the home, and give defendant 45 days to find an apartment of his own within Calhoun County. Because as has been stated within our answer, Your Honor, defendant has had 50-50 parenting time with these children their entire lives. He has been a primary co-parent with plaintiff. For her to state that she is the primary physical custodian during the time period that he was away trying to maintain this marriage, trying to save the marriage, he didn't have overnights, but that's simply the only thing he didn't have. He was still picking up children. He was still making sure that all of their needs were met. And so there's nothing here stated within this entire complaint that would say that defendant would require supervised parenting time. This nonsense about a past event that happened between defendant and his sister is absolutely irrelevant to this current case. Shouldn't have ever even been disclosed. However, plaintiff is trying to spin this as if defendant is this awful person. The event in question was something that occurred between two children. It was disclosed to plaintiff in confidence during a marriage communication, shouldn't be used. Defendant has absolutely no criminal charges against him, and defendant and his sister maintain a healthy relationship. Again, there may have been one incident where defendant ruined a trash can by throwing a cookie tray into it. That is not indicative of child abuse or any kind of domestic abuse. Parties who are having struggles get into arguments. Just because a garbage can was ruined because of a cookie tray does not, again, indicate that he has anger issues or is in need of a psych eval, nor is it indicative that he needs supervised parenting time. Nothing in here states that he has physically harmed the children, that the children are afraid of him. In fact, this Sunday they had church and rode with dad to church and were very excited to spend time with dad. The children love him. They have a healthy relationship. 50-50 parenting time should be ordered in this case. Child support pursuant to the Michigan child support formula. And like I said previously, if the court so desires to grant plaintiff exclusive use, give defendant 45 days to locate housing in the area so that he can not be driving over an hour to get to work and can still maintain his regular parenting time. We would ask that parenting time be week on, week off at this time. Thank you, Your Honor.
Thank you. Well, what the court does note, and there's no dispute that the parties separated back on April 6th, 2024. There's a dispute over what they were doing in the interim, but there is no doubt that, again, the defendant's contact with the children was limited during that time, with obviously no overnights, until he obviously moved back into the premises probably a couple of weeks ago. What the court's going to do is grant to the parties joint legal custody in the interim, grant physical custody to the plaintiff, order support consistent with the child support formula and the guidelines. Court is going to grant to the defendant standard parenting time commencing this week. Court would order that neither party would consume alcohol nor non-prescription drugs during the time they have the children in their care. The court will grant to plaintiff exclusive use of the property on Central Street and order that the defendant would vacate within 14 days of today's date. In the interim, because the parties each have an interest in the property, the court would order that the parties would each pay 1/2 of the mortgage, taxes, insurance during the pendency of this matter. I'll ask Mr. Todd that you would prepare that order and submit it under 7-day notice.
So, thank you, Your Honor.
Thank you. You're free to go. Have a good day.
Thank you, Your Honor.